with the 7th Circuit Court of Appeals. Testing 1, 2, 3. Testing 1, 2, 3.
How about the live stream?
Huh?
Good morning, everyone. We're here today for oral argument. We're going to begin with Appeal 24-3346, Maurice Holt versus Gary Boughton. Mr. O'Brien will begin with oral argument from you.
Thank you, Your Honor. May it please the court. After applying the Wisconsin rules of evidence, the Wisconsin Court of Appeals upheld the trial court's discretionary decision to exclude evidence from Mr. Holt's trial that had limited probative value and was otherwise cumulative to other properly admitted evidence. Holt failed to prove a Sixth Amendment violation here because whether or not you agree with the trial court's discretionary decision, he was able to robustly confront and cross-examine all of the witnesses against him, the two victims, his two cohorts who named him as the third robber. He was also able to present through his own testimony and through the testimony of other independent witnesses the dual defense of alibi. I was at home, well, I was with the Kellys through the weekend of the robbery, or as he told the police, I was at home with my girlfriend at the time, take your pick. And he was able to put on the defense of trying to point the finger at his nephew, Gaucher, as the third robber. The trial, as it played out, thoroughly shows that he was able to thoroughly put on the defense to confront his accusers, and he has failed, even if you assume error, he has failed to show harmful constitutional error.
If we do engage in the harmless error analysis, we use Brecht, correct?
Correct.
Thank you. You make it.
Yeah, and the Court of Appeals did apply a harmless error standard, but it was not the Chapman standard, because when it held a harmless error, it was reviewing the issue only as a matter of state law, and it applied the state civil harmless error test. So
but the district court applied Chapman.
I'm sorry?
The district court applied Chapman.
The district court did apply Chapman, and we believe erroneously. Well, and it also applied Brecht. And it's our view that the district court failed to hold Mr. Holt to his burden of proving, as required by Brown v. Davenport, of a grave error here that had an injurious impact on the outcome. With regard to the Strickland claim, applying the principles of Strickland v. Washington, the Wisconsin Court of Appeals upheld the trial court's decision after a thorough evidentiary hearing at which counsel and other witnesses testified, finding that Mr. Holt failed to prove deficient performance in some respects of the 13 claims he alleged, and failed to prove prejudice in all respects.
Mr. O'Brien, on the two deficient performance claims, two could give us pause. I'm not saying others can't, but the two might be the height question, because there was a jury question concerning it, then DNA, because jurors can place outsized emphasis on forensic evidence. With those two areas, should we conclude deficient performance on those, or what are your thoughts?
I would say I'm unwilling to concede deficient performance, but I think we can go to the prejudice analysis, because no one's DNA was found at the scene. Let's be clear.
What about the fact on the DNA evidence, though, that the lawyer made a promise about during opening statement about what the DNA evidence would show, namely that there was no DNA linking him
Correct.
to the crime, and then didn't present any evidence on it, and then talked about it again in closing.
Correct, but I would say that goes to the prejudice analysis. He, in essence, got it in through the back door. There was evidence at trial that DNA samples were taken.
But you can't say that came in the back door based on openings and closings, because the jury's instructed that's not evidence.
Correct. However, the prosecutor did not object, and certainly, but be that as it may, again, regarding prejudice, He's trying to point the finger at his nephew. No one's DNA, the other two robbers, nor his nephew's DNA was found at the scene. So if anything, even if counsel hadn't made those arguments, it's possible the jury could speculate, well, wait, the state took
What should
DNA
the
at the scene.
standard be here? I want to go back to the deficient performance for 1 second. We've said in the past that for deficient performance, if the attorney articulates a strategic reason for it, that it's not deficient. But here, the attorney during the post-conviction hearing essentially said, I had no reason for this. I had no strategic reason. So how does that factor into the deficient performance analysis? What should the test be?
Well, I think the test is that adopted by the court in Harrington v. Ritker, which is you look at whether counsel's performance was objectively reasonable under the circumstances presented at the time of trial.
So do we consider what counsel said? If counsel testifies and gives a strategic reason, we certainly consider that and defer to it. But if counsel says, no, I had no strategic reason, how should that factor in?
You know, at the trial level, trial judges will often make findings, credibility findings of, you know, I don't believe counsel's testimony, or I don't believe that was a sound strategic reason. At this point, especially given the deference owed on federal habeas, you look at overall performance, and we look at what happened at trial. We look at, yes, the post-conviction testimony, but we also look at his overall performance, which, whether or not he should have introduced evidence that Holt's DNA was not found, which of course would have been rebutted with evidence that no one's DNA was found, or regarding the height discrepancy, whether he should have put in evidence that they were off by 3 inches, or one of them was off by 3 inches, that the overall performance shows, and this ties into the presented defense and confrontation claims, that counsel put on a robust defense, did confront the evidence presented, and was able to lay out for the jury why Mr. Holt was not guilty, and that Mr. Holt was able to testify that he wasn't even there. And so you look at counsel's overall performance, and I think that's where we're not bound to what an attorney says. You know, I think it's Harrington v. Ricker talks about, you know, in hindsight, even the best attorneys will question their decisions and what they should and should not have done. I mean, that's reasonable. When you lose, you can always blame yourself for a number of things, but we're not bound to that, especially on habeas, but even on direct review. That Strickland is a very difficult standard to meet, and it should be, because we really, it's very easy for anyone to engage in 20/20 hindsight analysis and come up with 1, 2, or in this case 13 claims of, oh, counsel should have done this, should have done that, and we're not looking at the overall picture of what actually happened, how the trial played out. If we're just look at things in a vacuum and nitpick about, yeah, maybe he should have asked that expert. You didn't find Holt's DNA, did you? No. And then on cross, this date asked, and you didn't find anyone else's out either, did you? So this is really a non-issue. And as far as the height discrepancy, this was a brutal assault. People were, it was a chaotic situation. Descriptions, height descriptions, weight descriptions are often fluctuate, and yet what's really telling here is the weight descriptions almost match to the pound. And being off by 3 inches is, especially when these people are on the ground being kicked and beaten, one thing they were certain about is whoever did that was not there the night before, was not the 6-foot nephew who was there the night before. It was whoever this third man was that was not there. And his cohorts, Biddle and Dale, said it was Holt. And Holt confessed to Dale's brother in prison that, yeah, I pulled the gun, and I hope Dale doesn't snitch on me. This is all, so to make a long story short, you can focus on the prejudice aspect, and that is what the Court of Appeals essentially did for the most part. And whether you find 1 or 2 errors or 5 errors, it does not add up to a reasonable probability of a different outcome. It does not add up to the conclusion that Mr. Holt was denied a fundamentally fair trial. Counsel did the best he could to preserve that right, and Mr. Holt received that fair trial with a reliable, we would say reliable result. And excluding evidence that had little probative value and that was only cumulative to testimony from a credible detective as opposed to testimony from a not credible cohort to prove that 2 masked men, that Holt's nephew might have been one of the masked men photographed hours before the robbery.
Was there any offer of proof as to whether or not he could have identified the people in the photo?
Well, the offer of proof was that, okay, first of all, the answer is, I'll admit the trial court did not allow him to make an offer of proof. He wanted to question.
I didn't know if at any point prior to or afterwards or in post-conviction if there was something that I missed. I know the court didn't allow it.
In the separate appendix to my brief, you have both the Court of Appeals, where you have the Court of Appeals decision, but also the trial court's decision at the time, and then the post-conviction court's decision reviewing that. In the trial court, the defense attorney did say, Judge, I want to question, Mr. Dale was still on the stand while they took this issue up. He was still sitting on the stand. He said, I want to question him about this. And the judge said, and then he said, I believe he will be able to identify these 2 men as himself, and then the court interrupted and said, don't say who it is, don't feed him the answer. Then the discussion continued, and counsel said, and the court said, I'm not going to allow you to question him regardless of whatever his answer would have been. I find this evidence not relevant, not probative, because we can't see who they are. And then at that point, defense counsel said, I think he will identify himself and Mr. Gaucher as the men behind the masks. In violation of the court's order just a few minutes earlier, don't say who it is. So again, we're under the assumption that maybe that Dale might have said, yeah, those guys behind the masks, that's me and Gaucher. But that's certainly subject. Let's not forget that Mr. Dale came off as a very difficult witness for both sides. He admitted lying back and forth. He gave inconsistent accounts. He retracted his police statements. So really, whatever answer he would have given would not have proven much.
Would you reserve the remainder of your time?
I'm sorry?
Would you like to reserve the remainder of your time?
Certainly.
Thank you, Mr. O'Brien. Mr. Ruby, we'll now move to you for oral argument on behalf of the appellee.
Thank you, Your Honor. May it please the court, counsel. The jury that convicted Maurice Holt never got to hear the most compelling evidence supporting his innocence due to a combination of errors by the trial court excluding that evidence improperly or trial counsel failing to present that evidence despite it actually being his strategy to present these things. He failed to do so for a variety of reasons. The Court of Appeals unreasonably applied precedent from the Supreme Court when denying these errors. The district court disagreed and granted habeas. That decision was correct, and that decision should be affirmed. There are a few points that have been addressed so far this morning that I want to touch on. The court
Can I
raised,
just, before you go there, could I just clarify one thing, please, Mr. Ruby? Are you making a Sixth Amendment confrontation clause argument or just a Sixth Amendment complete defense argument with the Facebook photos?
it's both, Your Honor, because essentially there was.
For the Sixth Amendment confrontation clause argument, how could this photo qualify given the Supreme Court's case law that says this is extrinsic evidence is not subject to the confrontation clause?
Your Honor, when you're talking about extrinsic evidence, my understanding is extrinsic means something.
So
If
let me further
it's
elaborate.
directly relevant to the case, it would be usable for
But he was
cross-examination.
able to ask questions. The defense lawyer was not cut off, and the defense was able to cross-examine him thoroughly. This photo was a piece of separate evidence that didn't implicate the questions that were asked. Is it your argument that this line of case just wouldn't apply to it, or?
I think that counsel should have been able to question Dale about the fact that they took these photos, the circumstances of taking the photos, who was in the photos, the fact that Rayvon Gosha is the second person in the photos and he's the one holding the gun, what type of gun that was, where that came from. If you can't use the photos, it's very difficult to do that. So it definitely implicated his right to cross-examine Mr. Dale on that issue. My position is it's also a right to present evidence in his own defense because these are photographs. This is physical demonstrative evidence. So when the state talks about this being cumulative or covered by the fact that Detective Knoll testified about these photos at trial, the photos are the evidence. The photos are best evidence. It's visual, and you have to consider the importance of visual evidence for juries. And this goes to the Court of Appeals' ultimate decision finding harmless error, saying that the photos were cumulative. The photos are extremely important because in closing arguments, we're not talking about witnesses anymore. You put those photos up on a screen and tell the jury, here we have two of the robbers posing together just hours before the robbery, holding a firearm that very well could have been the firearm in the robbery because it's consistent with how the victims described it. And we've got Lindell Dale here in one mask, and we've got Raymond Gosha
Were
here,
any of those
one holding
facts
the gun.
contested? Were any of those facts contested at trial? Was the evidence that was depicted in the photos contested in any way by the state? I don't think it was, right?
There was testimony from Detective Knoll about the fact that there was photos taken with Dale and Gosha posing with firearms earlier. But it's still not the same as showing the jury the photos. Because, again, nobody talked about what that firearm looked like. So when we say cumulative, the photos can't be cumulative to one witness's perspective in what he saw in the photos because he didn't notice or testify, about the fact that that was a silver handgun, which is what one of the victims described.
But
So
how is
it's
that
not
a
just
constitutional
confronting.
violation? If he was able to get in the underlying facts, but not show the photo itself, what's the clearly established Supreme Court law that that's violated? I understand if you were making an argument to the trial court during the course of the trial, why you would argue that. That's a great argument for the trial judge. But we're at habeas, and it has to be a violation of clearly established Supreme Court precedent, and I don't think there's a case that says if you get in testimony about the underlying facts, and as Judge Kirsch pointed out, they're not disputed, but you can't bring in the photo, that somehow that violates a constitutional right.
Well, there's certainly plenty of case law on the fact of being able to present evidence in one's defense, and there's, I'm trying to think of the
So that
cases.
may not be your strongest argument.
It strikes me that your stronger argument may go to paragraphs 27 to 30 of the Wisconsin Court of Appeals decision. That harmless error analysis, if that's what it was, or evidentiary balancing, that's not the clearest drafting. in that area.
No, absolutely not. I agree with
It
that.
says it affirms for harmless error. As you point out, it really isn't potentially an evidentiary balancing that's going on before concluding that the exclusion of the photos was constitutionally fine. I think that passage can be read more than one way. Isn't that your better argument with regard to whether or not there's a constitutional violation?
Absolutely. That harmless error analysis didn't touch on any of the traditional harmless error standards. It basically just went back to whether it should have been admitted or whether there are reasons not to admit it. But it didn't talk about harmless error. An error has to be proven harmless beyond a reasonable doubt. It didn't
So
apply the burden to the state.
So perhaps the decision used a buzz phrase of harmless error, but not intending to do so in a manner that invokes all that law.
I agree with that. It didn't actually analyze the impact of the error on the evidence. The fact that the jury didn't get to see this very important visual.
Even if that's the case, then how does that even if we distance ourselves from the phrase harmless error, how does that itself, how is that incorrect in a matter that would allow for habeas relief, given that the Wisconsin Court of Appeals did engage in that analysis?
I think that it's contrary to the standard, though. The starting point of Chapman, again, is the error has to be proven beyond a reasonable doubt, and that the state has to have the burden of that. The error has to be analyzed, the impact of the error has to be analyzed.
I think we're under Brecht, though. I think properly we're under Brecht. I know the district court did engage in Chapman, but I think that Brecht is the correct focus.
Sure, I agree with that. The district court certainly analyzed Brecht, and it found grave doubt about this case for the fact that the jury didn't get to see that. Because, again, this is evidence that the defense could have used these photos not just to question Lindell Dale, but to question law enforcement about these facts. We have these photos. Did anybody show this gun here to the victims? Did anybody try to locate this gun? Did anybody question Lindell Dale about this gun? Did anybody question Rayvon Gosho about this gun? There was all these things that the defense could have done with this evidence, including putting it up there for the jury and emphasizing the importance of it, not just questioning Lindell Dale about it.
Even if the Court of Appeals, Wisconsin Court of Appeals, applied Strickland incorrectly, why is its application unreasonable? Isn't there room for fair-minded jurists to disagree about whether any prejudice resulted from the various failures we've been discussing?
No, Your Honor. Part of it is starting from the position of you have to consider the strength of the state's case. This is a weak case, regardless of what has been argued today. The circuit court acknowledged it was a close case. The district court said the evidence was not strong.
The Court of Appeals said we would not characterize the state's case as overwhelming.
Exactly. So the two witnesses, the two co-defendants that said it was Mr. Holt, both recanted at trial. The two victims who could not identify anyone initially said that the third robber was Deuce. Deuce is the nickname of Mr. Gosha. And although they backtracked later, that's where some of this evidence becomes so important. So we talk about the height evidence. It's not just the fact that Mr. Holt was 3 inches shorter than the victims described the third robber, which is significant because the victims described a robber that was the exact same height as them. It's also the fact that when asked how they knew it definitely wasn't Deuce, it wasn't Mr. Gosha, one of them said Mr. Gosha or Deuce is not the same build as the third robber. Well, nobody presented evidence on the fact that Rayvon Gosha's build, his height and weight, is exactly the description, exactly matches what the victims described for the third robber. So that is part of the impact of the evidence that trial counsel failed to present, that the Court of Appeals never actually addressed what the impact was. In its whole discussion of cumulative error analysis, it only talked about the state's evidence. It didn't talk about the impact of these errors. And one of the pieces of evidence that the court brought up is DNA. And I just need to correct something that has been argued here in the briefs and in court here today. It's been argued that, well, they didn't find anybody's DNA. And in the state's brief, it said specifically in the heading that they didn't find Holt's DNA or Ghosh's DNA or anybody else's DNA. The state crime lab did not test Ghosh's DNA profile against this evidence. So to say, well, they didn't find his DNA is meaningless because they didn't test that. But it is significant that Mr. Holt's DNA was not on this piece of paper that the victim said that the robbers were using to wipe off prints.
They did test Dale's though, correct?
It did test
And that
Dale's.
didn't show up.
Right.
Was that evidence presented to the jury?
No, there
Was
was
there-
no
was there
DNA
nothing,
evidence
so-
presented at all because the attorney wrongfully assumed that the prosecution was going to present the DNA expert when the DNA didn't help the state. So then he gets to court and there's no DNA expert and he can't present evidence on it. And I also have to correct this claim that it came up in the arguments and the prosecutor didn't object. He absolutely did object. He objected and he said that that never came in and the judge sustained it. So the jury did not hear any evidence on the DNA. I also want to address the question that the court raised about trial counsel's strategy and his testimony on that, how that impacts it. Counsel has cited the case of Harrington versus Richter, talking about what matters is what's objectively reasonable. But that case also includes a statement from the Supreme Court condemning engaging in post hoc rationalization that is contrary to the evidence available of trial counsel's decisions. Trial counsel's decisions and his strategy, the evidence about that is primarily his testimony. And his testimony at the hearing on all of this was that he wanted to do these things. He wanted Brittany Quaddy to testify. He wanted Michael Hayes.
What do you think the test should be? It's an objective test. If counsel comes in and testifies, as he did, that essentially I was deficient in not doing this, is that it? Do we find the performance standard met then, or is there more to it given it's an objective test?
I think there's still an element of reasonableness, both of the strategy and the failure to execute the strategy, and looking at the reasons why the strategy wasn't executed and whether those were reasonable. So that gets into things like the complete failure to make actual efforts at subpoenaing this hard-to-find witness by using the sheriff's department or a private investigator when the attorney knew that this witness was difficult to find and waited for any attempt at real process service until the last minute, which Seventh Circuit cases have already talked about how that's not reasonable. So when we talk about the fact that Brittany Quaddy wasn't there and evaluating counsel's decision, his decision was to call her. He wanted to subpoena her. He wanted her there, but she wasn't there because he unreasonably failed to subpoena her and make efforts in advance. With Michael Hayes, there was no decision not to present his testimony. Again, counsel subpoenaed him, but counsel also didn't review the recording of his statements that showed how important his information was, putting Rayvon Gosha with one of the other robbers before the robbery and after the robbery, putting Rayvon Gosha driving the getaway vehicle, basically, or being the driver of the vehicle that was later found full of items stolen from the robbery. Obviously, counsel's...
Didn't he say though in his statement, didn't Mr. Hayes say there was no discussion of the robbery during that time when he drove them?
Yes, that was what Mr. Hayes told the detective about that point.
Mr. Ruby, where is Mr. Holt? Is he in the Wisconsin Correctional Services?
Yes,
He's at,
he's in Jackson Correctional.
very good. Thank you, Mr. Ruby.
Okay, thank you.
Mr. O'Brien, we'll go back to you now for rebuttal argument. We'll give you 2 minutes.
Regarding the photographs, the question is, what did they prove? What they prove is that 2 masked men, masked persons, we don't even know if they're men, brandished weapons hours before the robbery. That's it. He wanted to ask Dale if one of them was him and if one of them was Gaucher. And again, as I said earlier, regardless of how Dale answered that question, because of his other credibility issues,
What about the argument the photo could have been used with other witnesses?
I'm sorry.
What about the argument that the photo could have been used with other witnesses besides Dale?
Again, it's cumulative. The detective already testified. Detective Knoll testified that he himself personally had seen Facebook photos of the unmasked Dale and the unmasked Gosha taken hours before the robbery. So sure, they could have been shown. And, you know, again, if you look at the photos, what do they prove? You can't, you know, they say a picture is worth 1,000 words. Among the words there are not, this is Lindale Dale and this over here is Mr. Gosha. They don't tell you that. Someone else has to tell you that. The photos don't tell you that. Moreover, counsel makes a big issue out of the identification of the weapon. Well, first of all, these are pretty generic weapons, but more importantly, to the extent you can even see them, but more importantly, when Mr. Counsel for Mr. Holt tried to introduce those photos, that was not one of the reasons why he wanted them admitted. He didn't argue. This also shows that the guns that were used, and they matched the guns described by the victim. That argument was never made at the time. And the post-conviction court and the Court of Appeals pointed that out, that particular rationale for admissibility was forfeited.
Thank you, Mr. O'Brien, and thank you, Mr. Ruby. The case will be taken under advisement. We're going to move now to Appeal 25-1419, Vivek Bedi et al. Versus Premium Healthcare Solutions, LLC. We're going to begin with oral argument now from Mr. Schwartz.
Good morning.
Morning.
I represent the intervener and the appellant in this case, Vivek Bedi. This is a dispute between two judgment creditors. The intervener, Mr. Bedi, who obtained a judgment in state court in 2022, and the plaintiff in the federal case, who obtained a judgment against the same defendant in 2024.
Mr. Schwartz, I have a question for you. How could Ruckler-Feldman apply when in 2022 your client obtained a judgment against a company that didn't exist called Premier Healthcare?
Your Honor, he got the judgment against the correct defendant. The name of the defendant, it's a misnomer. It was called Premier, and it should have been Premium.
I know.
There is no Premier.
I know there isn't. So how could Rooker-Feldman apply? I mean, it's a stretch. The Rooker-Feldman is a stretch anyway, but how could Rooker-Feldman apply in 2022? I mean, are you suggesting that MedLegal should have been aware that your client sued the wrong defendant in 2022 and should have entered in the state court at that time to correct that error? I'm not sure. How could Rooker-Feldman apply to those facts?
Well, the misnomer, it's a misnomer that a clerical error could be corrected, and it was corrected non-pro-tonque. But the plaintiff, MedLegal, did not, there's no claim that MedLegal relied on that judgment in any way, or that they were prejudiced in any way by the fact that the debtor was spelled Premier instead of Premium. What would MedLegal have done differently had it been the proper spelling?
I don't have any idea what they would have done differently, but I certainly don't expect that they would look. I mean, if you're doing public record searches, you don't look for the wrong name.
Well, Mr. Bedi was also, the principal was also a named defendant in that case. And if they had done that search, they would have done that. But what is when you say they should have done a public record search?
No, I'm not saying they should have done a public record search. I'm just saying, how would they even know that Premium was being sued. You're saying, oh, it's a misnomer, it's not that big of a deal, but it is kind of a big deal. It's not the right defendant.
I guess my response is, how are they prejudiced by that? We're not claiming that we're not suing MedLegal because they didn't give notice.
Well, I think on the Rooker-Feldman issue, you're saying that MedLegal is a state court loser. So MedLegal wasn't even a party to the state court litigation, but the state court litigation was against a different defendant. It was against a company called Premier that apparently doesn't exist, or maybe it does exist. I don't have any idea, but it wasn't against Premium. So how could they be a state court loser in litigation that was against the wrong defendant? That's where I'm having trouble. I'm having trouble understanding that part of your argument.
Fair enough, and I'll address that. So the judgment was against Premium. It was a misnomer called Premier. MedLegal stands in the shoes of the judgment debtor. As a judgment creditor serving third-party citations, it stands in the shoes of the judgment debtor, which is Premium. It is Premium that judgment in 2022 was entered into. It was, on the paper, it'd be no different than if they had a judgment against me and they left out the Z or something, and then they went in with, I won't mention that because I just saw someone left out my Z in my name.
So it doesn't affect your credit rating, right?
Again, if it was a substantive, if there was another company out there and we sued the wrong company, or there was two companies with the same name and we sued the wrong company, that would be a different issue. But to say that someone loses all their rights because the name of the defendant is misspelled, when everybody, well, the parties to the lawsuit certainly knew who was the intended defendant.
Let me move you to appellate jurisdiction, because the parties disagree with regard to that. One of the arguments is concerning the Declaratory Judgment Act. That act only applies to judgments that are issued in response to, quote, appropriate pleadings, end quote. There isn't a declaratory judgment action here, filed under 2201. There was a motion for partial summary judgment. There was decretal language that was seeking certain relief with regard to judgment as a matter of law, as well as a declaration. I'm wondering if there's real difficulty here in us hearing this case as a result of the fact that a ruling was made by Judge Alonso with regard to that motion, but the case continued. It wasn't as if a Rule 58 judgment came down. It wasn't as if the case ended in the district court. There are still proceedings that can be ongoing in the district court, and does that present a problem for our appellate jurisdiction?
I don't believe it presents a problem, because all the issues between Mr. Betty and MedLegal have been resolved. There's no pending claims or issues between those parties. The only issue was priority.
What's the status of your adverse claim in the district court?
It's moot, because the intervener has a state court judgment. It can't go into federal court in a federal proceeding and enforce its judgment. The intervener has not filed any supplemental proceedings, citations, garnishments in the federal court. Again, it has a state court judgment, and it's proceeding in state court with supplemental proceedings, subject to waiting for this court and a state court appeal, but it is proceeding. So there's nothing going on between MedLegal and the intervener in this case.
Is
So
there anything left to be done in the district court with respect to your client and
None.
not legal?
None. The plaintiff suggests that the intervener's claim has to be adjudicated whether he has a valid claim or not. But I don't know who would be litigating it. The plaintiff certainly doesn't have standing once it has priority.
I don't think the plaintiff has suggested that the federal court has to litigate that, because the only issue with respect to your client was the priority of the lien, and once the court made that determination as to your client, That's it, is my understanding,
Yes, and
in federal court.
that's why it's a final order.
Why would your client then give up all those arguments on the merits? Why would your client offer arguments in the merits if it was going to be bound in the way that you're talking about?
Well, it only argued that the federal court did not have jurisdiction under the Rooker-Feldman doctrine to consider the plaintiff's arguments that what they claimed the state court judgment in 2022 was not a valid judgment against Premium.
But if we find appellate jurisdiction and we move through the Rooker-Feldman question and we get to the merits, we're still looking for Mr. Betty's arguments with regard to the priority, aren't we? I mean, aren't those absent from the record?
Well, I don't believe so. Within the record, it shows he got a judgment and a judgment lien in 2022. There's an order correcting the misnomer, and the law is clear, twofold. One, first in time has priority, and second, if it's nunc-pro-tunc, which the misnomer was corrected nunc-pro-tunc, then it is retroactive.
So your argument is that there's enough in the record?
Yes, absolutely. And again, we raised...
I think the challenge is in responding to the motion for partial summary judgment, you relied on Rooker-Feldman, but you didn't make these lien arguments and priority arguments before the district court.
That is correct.
I think that's what Judge Brenner is getting at. If not, I will ask the question that, why haven't you waived it? Because you didn't make those arguments about lien priority below. We're seeing those for the first time on appeal.
Well, because if Rooker-Feldman applies, then the federal court would not be determining who has priority.
So what if Rooker-Feldman doesn't apply and you didn't make those arguments below? Have you waived them?
Your Honor, candidly, I would have to say, I won't concede that it was waived, but we put forth the evidence was sort of in the record. They did not argue that in response to the summary judgment. But certainly the evidence that would support these arguments, the date of the lien, the nunc-pro-tunc, et cetera, that was all in the record. And I think it's just as a matter of law, no one disputes that the judgment lien first in time has priority.
Are you litigating the adverse claim issue in state court? Because the district court didn't address that because it found that MedLegal had priority here, so it didn't have to address anything else. Are you litigating the adverse claim issue in state court?
Yes and no. We are litigating in state court an adverse claim, but it's the adverse claim that MedLegal has intervened in the state court to assert their adverse interest to Mr. Petty's judgment. And that's on hold because there's an appeal in the state court case by MedLegal refusing to allow them to intervene to attack the nunc-pro-tunc order, but they were still allowed to intervene to assert their rights as an adverse claim.
Mr. Schwartz, would you like to reserve the remainder of your time?
I would.
Thank
you very much.
Thank you very much. Ms. Skochelis, argument for the appellee. How did I do?
Close.
Okay.
Christine Skochelis on behalf of Appellee MedLegal. I want to start with appellate jurisdiction, and respectfully, Judge St. Eve, I think there were other things to do that no one's talked about yet in the district court, which actually did happen. If you look at the life cycle of a citation proceeding, it starts as citation proceedings commence with the service of a citation to discover assets. And this court has recognized that the service of each citation starts its own discrete proceeding that's treated like a standalone lawsuit. If assets are discovered and there is a party who claims to have an interest in that asset, they can come forward and intervene and make an adverse claim. And that adverse claim will be tried and resolved in that specific citation proceeding as if it were in a garnishment proceeding. That's what.
So are you saying that Mr. Betty's adverse claim will be litigated before Judge Alonso? Because that's not what I'm seeing in the record below, given the lien priority determination.
Well, we haven't gotten to a really important step yet. And I think to your question, if you look at the converse, what if I lose my partial motion for summary judgment? Are we done? We are not. I'm going to go collect evidence, and I'm going to go insist on a trial of his adverse claim. And it'll be his burden, but he'll need to show that he does have a valid claim.
But you don't
But you
need to do
won.
that since you won.
Right.
That's true, but there still was something to be left, which I don't know that anybody's really addressed well. After the lien priority ruling, I filed motions for turnover orders. For example, for BMO Bank to turn over the substantial sum of money that they had in their frozen accounts that belonged to Premium. And the judge granted those, relying on his interlocutory order of MedLegal having lien priority. Now, the Illinois Supreme Court rules say this, and this court has also said this: turnover orders are final and appealable because they resolve all of the issues related to that specific asset that was at issue in that specific citation proceeding. And appellant could have appealed the turnover order. For example, the BMO Bank turnover order. He could say, you know,
But
I'm
are
gonna-
these turnover orders that are in Mr. Betty's name, for accounts in Mr. Betty's name? Or
No, Premium.
So again, how would that impact the citation, the intervener's motion filed here? If you were here and Premium was appearing, I think you'd have a stronger argument. But the issue as to Mr. Betty looked like it was a very discrete, separate citation to discover. And as you said, we have said citations to discover assets are their own unique individual cases.
So the adverse claim is part of a citation proceeding. It is not its own proceeding. You have to bring it if there's already a citation proceeding, such as the BMO Bank proceeding.
So let's assume you were affirmed here. We take the case. We find we have jurisdiction. We affirm. What's left to do before Judge Alonso as to Mr. Betty?
Ask for the turnover orders that says, BMO Bank, you give Premium assets to MedLegal and not to Mr. Betty, who claims to have an interest, but I've decided that they don't have a lien priority. And if Mr. Betty's unhappy with that, he says, no, I'm going to appeal the turnover order. I want you to put on a stay. I don't want BMO Bank to turn anything over to MedLegal until my appeal is resolved. And if he had appealed the final and appealable turnover orders, that interlocutory priority ruling would have been merged into that.
Do the rules though provide for or allow for such interlocutory up and downs between a priority ruling and a citation order ruling? That seems to be awfully inefficient and not what the rules or the statutes provide for.
Well, I think
It goes to your argument on pages 3 to 9 of your brief that there is no appellate jurisdiction.
if you look at it, like I said, in the converse, if MedLegal had lost on the priority issue, there would have been more to do. And ultimately, after, does he have a valid claim, does he not have a valid claim, someone is going to go ask for a turnover order. And that's the order that is final and appealable. There's no question about that in state court and here. And if you think about interlocutory orders getting merged in under Appellate Rule 3C7, you can see the interlocutory nature, because if he's found to not have a valid claim later, if that's how things go, then that interlocutory ruling really doesn't matter. Also, if that interlocutory ruling is found in MedLegal's favor and it turns out there aren't any assets that get uncovered, I'm never going to file a turnover order. Is he allowed to is that a final and appealable order, the lien priority ruling, that he can go appeal now? It's moot too.
So which is it? Are you arguing the counterfactual, that there is jurisdiction and that will be the result, or are you still standing in the position that there is no appellate jurisdiction?
There's no appellate jurisdiction. That lien priority order, although it was necessarily incorporated into those final and appealable turnover orders, isn't itself final and appealable, because that didn't resolve all issues related to the specific asset that was at issue in the specific standalone citation proceeding.
Let me ask you about docket entries 72, 73, and 74 in the district court,
Yes.
a motion for partial summary judgment. It is captioned partial summary judgment.
Correct.
However, the decree to language says asking for judgment as a matter of law, and it does use the verb declare. Does that run into a problem with, I'm thinking the Wachovia case and some of our other cases on declaratory judgment?
No, I don't think it does. This court has counseled that not every declaration of some rights makes an order immediately appealable. You can't just slap a declaratory label on it and manufacture finality. And, you know, the court still has to do the Section 1291 analysis to see if the order is final and appealable. And under the Wachovia line of cases, it was unmistakable that the court meant to rule on and dispose of in full a declaratory judgment claim. And that is not what happened here.
Thank you.
If I could just turn briefly to the Rooker-Feldman argument, I think Judge Kirsch, you hit the nail on the head. What would MedLegal have done differently? How were we prejudiced by that non-proton order? Well, I'll tell you, before we pursued collections, I looked on PACER and the federal dockets, I looked through Cook County's records, and I scoured DuPage County's records for a judgment against Premium, because that's my judgment debtor. Apparently, there was a judgment against Premier there. I wasn't looking for Premier. Of course I wasn't. Had they done things right before the DuPage County Court, and I saw that there is a pre-existing judgment against Premium, my client and I might not have pursued collections. I don't know what we would have done, but it certainly would have changed our analysis of whether to pursue collections.
In your partial motion for partial summary judgment, though, don't you concede that the state court judgment prejudiced your rights?
No, I don't. I know appellant says MedLegal conceded that, but we did not. It's not the judgment itself. The fact that appellant won a case against Premium or Premier. It's that MedLegal lost its place in the priority line. That's really what prejudiced us. If the non-proton order has the legal effect that appellant would like it to, his lien would be superior to MedLegal's lien. That's the prejudice. MedLegal doesn't get to collect on his judgment immediately. There's time value of money. There may not be any money left in the bucket. That's the prejudice. And that non-proton order is not correcting a clerical error. I know he calls it the misnomer order, but it affected a substantive change by extending liability to Premium, who had never been liable to appellant before. And that's a substantive change that affected a third party's rights that already existed at the time that non-proton order was entered. That is not what non-proton orders are meant to do, and Judge Alonzo correctly found that the non-proton order did not have that legal effect.
What's the status of the citation to discover assets below now?
Currently, there are none pending. I don't think the court would have jurisdiction to enter turnover orders right now anyway.
I think Judge Alonzo found that. Didn't Judge Alonzo find that when there was a motion to clarify something?
Oh, yes, one of the attorneys who also got a citation after my citation asked
It's
for
on appeal,
clarity.
you can't do anything.
There's federal order on this end, and there's a state citation that says I can't do anything with money, please help. And he said, well, let's see what the appeal happens. There is citation proceedings pursuant to Mr. Betty's citations that he served later in DuPage County.
But not on this case.
No, not in
They're
this
on a
case.
state court.
Yes, exactly.
Do you have any turnover orders pending? Motions for turnover?
I don't, but I have since learned that there are other respondents that do have money, and if the appeal is dismissed for want of appellate jurisdiction, or if Judge Alonzo's order is affirmed, we will move for turnover orders on that asset. All right. If there isn't anything further, we just ask the court to dismiss the appeal for lack of appellate jurisdiction, or if there is jurisdiction, to affirm the district court. Thank you.
Thank you, Ms. Kochelis. Mr. Schwartz, we'll move back to you now for rebuttal argument.
Thank you. On the issue of jurisdiction, I'd like to reiterate, there's nothing, Mr. Betty is not pursuing any supplemental proceedings, nor do I think he can pursue supplemental proceedings in federal court on a state court judgment. So the only relief Mr. Betty could have is that he would have priority over these assets. And the district court judge ruled on that, and there's nothing left for the district judge to do with respect to Betty's claims. All the other citations, as counsel says, those are separate proceedings. That doesn't affect this court's jurisdiction. The other point I want to point out is, for purpose of nunc-pro-tunc, the DuPage County Court changed the misnomer nunc-pro-tunc, which means that the judgment entered against Premier was actually intended to be against Premium. The district court judge, I say in violation of the Rooker-Feldman doctrine, disagreed with the state court judge and said something that the nunc-pro-tunc is not effective or doesn't apply. That's the only way he could have made that ruling on priority. I will point out that in the Seventh Circuit, this court, in the King case, 825 F. 2nd, 1180, it's cited in the appellee's brief, the court acknowledged that if an order is entered nunc-pro-tunc, that was a dispute among priority of creditors, and there was a citation proceeding that was lapsed, and then it was reinstated, and the issue was whether that was nunc-pro-tunc, so that the lien remained in place for the citation, or it was a new citation. The court didn't, the lower court didn't rule whether it was nunc-pro-tunc, and the Seventh Circuit said if it was nunc-pro-tunc, then that creditor would have priority. But since it wasn't nunc-pro-tunc, the creditor doesn't have priority. In this case, the correction of the misnomer was nunc-pro-tunc, and therefore the date of the judgment is the judgment that was entered in October 2022. And I cite some state court cases that say correcting an order nunc-pro-tunc does not affect the finality of the original order. Again, it's merely a clerical change to the name of the defendant.
Thank you, Mr. Schwartz.
Thank you very much.
Thank you, Ms. Kochelis. The case will be taken under advisement. Thank you. We're going to proceed now with Appeal 24-2244, United States versus DeAndre Owens. Ms. Christensen, we'll begin with you.
Thank you, Your Honor. May it please the court, counsel. Good morning. My name is Joanna Christensen, and I represent the appellate DeAndre Owens in this case. The handling of the dual testimony case in this case is reversible error, plain or otherwise. Detective Dukes and Agent Parker testified as both lay and expert witnesses, and no attempt was made to follow the precedent in this court's United States versus Jett.
With respect to the jury instruction on that issue, Ms. Christensen, neither side asked for that instruction, and I think we've been pretty clear that courts don't have to sua sponte, bring up instructions if not asked for it. So how could that be plain error that that instruction was not given? I understand you have an argument about the procedure itself, but you've also argued the jury instruction that came out of Jett, and I don't know how that could be plain error or even error given our case law.
I think that you're right, there are many levels of error in this case, and while I would hate to rank them, there are some that are less important but add to the final error in this case, which makes it plain. And the jury instruction, of course, was not asked for, but JET has other procedures that should be followed. And when that becomes clear to the district court judge as part of the judge's gatekeeping of expert testimony and testimony in general, that should have been enough to at least prompt the court to both ask the government to structure
But what
its
law
testimony.
supports that? And again, we're on plain error. We've said, I think we recently said it en banc in Page, that courts don't sua sponte have to raise jury instructions if neither side asks for them.
Right, and I think that in JET, there was the conversation about the formal jury instruction, but it's also discussing with the jury at the moment when the dual testimony is taking
Right, the
place.
procedure during the testimony.
Right.
And I think you agree, nobody asked for a particular JET procedure here either.
Right, nobody asked.
Why would, by the way, as a strategy matter, why in the world would the defendant want to do that in this case? Why? I mean, these agents are unquestionably qualified to testify to the simple matters on which they're testifying. Why in the world, as a strategic matter, would defense counsel want the judge to interrupt the testimony and explain to the jury that the witness who is about to give percipient testimony is an expert?
I think that the error comes in Agent Parker's testimony because he testified particularly about the recording device only as an expert. He had no familiarity with the actual recording device used. And that bolstered both his testimony then later, but also Anderson, the CI's testimony, and then Duke's testimony as well. So he came in and talked about that this is the way it works, you can't tamper with it. That went straight to the defense's argument at trial, that there had been some sort of tampering, that Anderson...
But the judge isn't going to tell the jury that the witness is not credible or to disbelieve him. The judge, if anything, is just going to help the government. I mean, as a strategic matter, I can't imagine a defense attorney who would want to say, now, Judge, after he's given this expert testimony, tell the jury that he's an expert. Just go ahead and tell him that. What sense does that make?
I think framed that way, yes, Your Honor, it seems like an odd one, but framed in the way when you tell the jury that there's a difference between testimony from the witness, that they actually observe something, so that he actually observed.
But that
the
came out on
device.
cross-examination. Like, that's the whole function of cross-examination. Agent Parker, you didn't participate in the control by, right? You don't know how the system was working on that day, right? I mean, it's great cross-examination.
Sure, but we also have the judge not instructing the jury, and the jury perhaps not knowing exactly what to do with these
So we're back to
different
the
layers.
instruction again. That wasn't asked for. And consistent with JET, the agent gave the testimony first, that was the opinion testimony, and then went on to factual testimony. And that's what in JET we directed that you do. So even though you claim there's a JET error, in terms of structure, that's how Agent Parker testified.
I think
So we're back to the instruction.
well, you also have to look at the way the witnesses were presented. We have Dukes, then Anderson, for quite a long time, who was a not very credible witness and had problems both with defense counsel and with the court. And then you have Parker. So it's not just that Parker's was structured.
But JET doesn't address that. JET doesn't say that you have to put on dual experts in any particular sequence. It just says when you put on a witness who is a dual witness with expert and fact testimony, that you should follow these procedures and make it clear what's opinion testimony and what's factual testimony.
Right, and that's why this case is a step beyond JET, because JET didn't have that issue. JET went back and forth.
But how could it be plain error then, if it was not something we said you have to do in JET?
It's plain error based on the handling of the expert and lay testimony with various witnesses. Also, with the lack of instruction both procedurally and the jury instructions themselves.
So specifically, given that for both of the witnesses who were dual witnesses, they gave their expert opinions first and then went on to the factual. They didn't mix back and forth expert fact, which is what we said in JET you shouldn't do. So they followed that procedure. The judge did not sua sponte give an instruction, which we've said courts don't have to do. What is the exact violation of JET that you, or the plain error, given that you think exists?
The plain error, I think we see more back and forth with Dukes because Detective Dukes actually dealt with a recording device. So he testifies about the recording device as an expert. Then he talks about how it was working during Anderson's interaction with Mr. Owens. And then that goes on for quite some time because that was the primary defense argument for the jury. And again, then you have Anderson in the middle with the credibility and then coming back with Agent Parker bolstering the credibility about that recording device. That was really unnecessary testimony because he was there solely to give testimony in that, and that's where you see defense counsel objecting to the type of testimony he's giving, unsure about what he's going to say as an expert or not. And then again, then he moves on to his fact portion, the handling the methamphetamine, and then you have him on the second portion of the trial about the 851 notice and then the committing the offense while on pretrial release. So that it does talk about the aura of reliability that this dual testimony will give to the witness themselves, but also to other witnesses. And that's the plain error here, is that was allowed to continue. So, and in the government's brief, they cite the Supreme Court Frady case about plain error and that, to the extent that the court and the government were derelict in not noticing. I think that yes, it would have been a better case here, absolutely, if defense counsel had made the objection, asked for the instructions. But at some point, when JET has been law and dual testimony has been decided by this court, it does fall upon the court and the government to follow the appropriate procedure.
Can I ask you a question about Officer Herzing, who was incorrectly included as giving opinion testimony in the jury instructions? Mm-hmm. What is the prejudice to your client from that?
That again is one of my lower errors. It was an error. It shows that there was error in here and probably confusing to the jury.
But for plain error review on prongs 3 and 4, the only argument I saw in your brief was that his testimony went to the heart of the defense about the recording being turned off, but Herzing testified about count 2, the witness tampering,
right,
not the recording piece and the buys. So I wasn't sure what the prejudice, how you meet, what your argument as to prongs 3 and 4.
Yeah, my argument for prongs 3 and 4, Herzing, if I did say Herzing went to the heart of the defense, that must have been an error in my brief, talking about the wrong law enforcement officer, because he was the second,
correct,
second count. So, I think that it's that confusion to the jury, but if we're talking about the second or third and fourth prongs of plain error, the fairness to, the fair trial to Mr. Owens, of course, when the jury hears all of these things and they're not explained to the court or to the jury about how they're supposed to.
And what would the prejudice be? Because the instruction, it says he's giving opinions. It doesn't label him an expert. We consciously gotten that out of prior versions of instructions. It just says he's giving opinions. So how could that be prejudicial in this case, as to Herzing?
Oh, as to Herzing, it was simply that he did not give opinions in the way that Dukes and Parker also gave opinions. Herzing gave some, if I'm remembering correctly, some interpretation about what the conversations were about the witness tampering. But those, and this court has held many times, that kind of interpretation about either text or voice calls is appropriate for law enforcement to make based on their experience in that case. So the simple fact is the confusion. That's where any prejudice would come, is the confusion by including Officer Herzing in that instruction.
So to reserve the remainder of your time?
Yes, thank you.
Thank you, Ms. Christensen. Ms. Hudson will now move to you for oral argument on behalf of the appellee.
May it please the court, counsel. Appellant has raised two issues, discrete issues on appeal. The first has to do with a lack of contemporaneous objection as to trial court errors. The second has to do with sentencing perceived error that was withdrawn at the district court and is waived and not subject to review. I will spend my time discussing the trial court errors and first apologize for the error. It was my fault. I did not follow JET. I should have, and would like to move forward from that and simply say that prongs 3 and 4, given the evidence adduced at trial, simply cannot be met. There is no evidence that should show the court the defendant's substantial rights were affected and that there's a reasonable probability, but for my error, that the outcome of the proceeding would have been different. I would turn the court's attention to the testimony of Lieutenant James. There was no objection to his testimony at the trial court level. There's no issue raised before the Court of Appeals regarding this testimony. And he very clearly explains that the witness, Mr. Anderson, was unable to manipulate the recording device, that it was turned off by either Officer Dukes or Officer Castleman, and defense counsel was given an opportunity to cross-examine this witness as well. There was some issue regarding the video recording being turned off prematurely, but believe that may have been an error on the part of defense counsel in downloading the video. But she did, in great extensive cross-examination, did examine all the witnesses about where the witness was, where the cooperating source was, and did attempt to make an argument that perhaps during this moment or that moment a second buy occurred, but there was no real evidence that would cause this court to find that the jury would have returned a different verdict had the JET procedures been employed here. Finally, with regard to the fourth prong, a serious effect on the fairness, integrity, and public reputation of the judicial proceedings, I respectfully submit to the court that the fact that the defendant reached out to the confidential source and offered a $10,000 bribe rendered the evidence against him overwhelming. This is an individual who not only was in the videotape, was following the confidential source, called the confidential source with records recording that presented to the jury. This is an individual who reached out and tried to bribe him. The jury was able to hear that, and should the court return the case for a new trial, the jury would hear it again. It is direct evidence of his consciousness of guilt, and therefore we respectfully suggest that it is overwhelming. Appellant has also indicated that she believes that Special Agent Parker's testimony regarding the 851 enhancement and the fact that the individual was on supervised release at the time of the offense, the aura extended to that information as well. However, I would point the court's attention to the record, document 110 and 148, I believe. The district court made a finding in advance of trial that these documents were admissible, therefore his aura would be decreased as it relates to these independently admissible documents. As it relates to the sentencing, I believe that the evidence is sufficient to show the court that this is a waived right, and unless there are further questions, I would ask the court to affirm the judgment and the sentence.
Ask you one quick question.
Yes, Your Honor.
On the sentencing issue and the Ruth issue,
Yes, Your Honor.
both, I think it's Justice Barrett and Justice Sotomayor, have urged the Sentencing Commission to take this issue up given the circuit split. Do you have any idea where that is? I know they attempted a year or two ago and it wasn't in the final amendments. Do you know if they're still working on that?
Your Honor, I apologize. I do not know the answer to that.
That's okay.
I'd be happy to give supplemental briefing should the court wish.
No, that's okay. It was more out of curiosity, given that this issue repeatedly comes up.
Yes, Your Honor.
Thank you.
Thank you very much.
Thank you, Ms. Hudson. Ms. Christensen will now move back to you for rebuttal argument.
I'll start briefly with the Ruth issue. I don't have any more knowledge about the Sentencing Commission either. My understanding is that they have been working on it, but I think it is a difficult issue to resolve by the Sentencing Commission. But at this point, we're preserving it for further review. We've not been successful. I've been preserving it since Ruth.
Everybody tries to get Ruth overruled.
I am ever hopeful about many things, not just Ruth. But I will talk a little bit about the overwhelming evidence. The overwhelming evidence about the witness tampering, I can certainly concede that from the government's point of view, and we're not contesting that. But what this goes to directly is the drug offense evidence and the defense theory that this was something that was orchestrated by Anderson, that he obtained it somewhere else. So the third and fourth prong of plain error are always difficult, but in this case, I believe they are met because of the lack of fair trial on that drug offense issue, and that the way the evidence was handled affects the fairness and integrity of jury trials in general when this continues to happen. So unless the court has further questions.
No, thank you, Ms. Christensen. Thank you, Ms. Hudson. The case will be taken under advisement. We're going to move now to Appeal 25-1416. Strike that. Appeal 24-2683. United States versus Rob Darius Williams. And we're going to begin with oral argument again from you, Ms. Christensen.
Thank you, Your Honor. May it please the court, counsel. Again, I'm Joanna Christensen, and this time I represent Mr. Rob Darius Williams. So the evidence in this case was insufficient to show that Mr. Williams had advanced knowledge that his co-defendants were going to brandish the firearm during the AT&T robbery. Although the standard is an uphill battle, in this case, the lack of evidence was a manifest miscarriage of justice.
And I think you agree plain error review applies here?
Yes, plain error review does apply. I think in the sufficiency of the evidence realm, it's all a little bit the same. It's hard to delineate between sufficiency, manifest miscarriage, and plain error. So I think I'm arguing essentially that the error here was so great that it meets any standard for reversal.
And you are not challenging the 924C jury instruction here, correct?
No, that was correct. And that came, of course, from Rosemond and Armour. But the evidence was not sufficient. In essence, the jury got it wrong in this case.
To satisfy the brandishing label, is it necessary that your client have seen the gun in someone else's hand and raised? Is it that level of specificity that would be required?
You mean the gun was raised?
Yes.
I'm not sure that that's required for this conviction, because I think the part of brandishing is the intimidation factor. So when you see other cases discussing this, the defendant at issue may not have seen it at all. It was a driver like Mr. Williams was a driver, but that there was evidence that he knew beforehand that his co-defendants or co-actors were going to brandish the firearm.
And I'm trying to discern that line. Is it foreknowledge of intimidation using the weapon, or where is that line?
The line, admittedly, is difficult, because when you're talking about using the weapon, that of course goes to the carry, use, possess portion. The only thing that I can fall back on, of course, is the definition of brandishing and that intimidation factor. So it was clear, and I've certainly conceded, one, that Mr. Williams participated in the robbery, and two, that he knew that a gun was possessed, certainly. But there's just not enough evidence there to show he knew beforehand that it was going to be brandished by his co-defendants in the store.
So a co-defendant saying, I've got a gun in my pocket, I'm using it as a backup, but I'm not going to bring it out unless there's a problem. A statement like that would exculpate from the use of brandishing?
Possibly, except for your part that said unless there's a problem. I think that might be just another step toward brandishing, because it does show an intent that this gun is going to be brandished inside. But we have none of that testimony here. We have no idea.
Does it make any difference that it was a rifle?
It makes a difference as far as the size. It is harder.
Because the reason I ask you is that, they went to pick up the gun before the robbery, and your client knew that they went to pick up the gun, he was with them. if it was a revolver, perhaps the robber could have put the revolver in his pocket. And
Sure.
it would not, but I don't know why you pick up a rifle and bring it into the AT&T store if you're not intending to brandish it. Seriously, I mean, what are you gonna do with a rifle?
Sure.
And why couldn't the jury just reach that conclusion that your client was leading the robbery, at least participating in the robbery, your client had advanced knowledge that they had picked up the rifle? It just looks a lot like armor to me.
I think it is possible to conceal a rifle, and in this case, the RISPer, who is the one who ultimately took it into the AT&T store, did conceal it. It was in his pants and under his sweatshirt. So it wasn't a full-length rifle, to my understanding, is that it had a pistol handle on it, so the longer rifle handle. So it was a little bit shorter than it would have been. It was a large gun. But the problem with making that leap to the size of the gun being automatically means you're gonna brandish it, eviscerates the use, carry, possess portion of the statute.
Yeah, I'm not saying that that we would just rely on that, right? I agree with that, but it's one factor. I mean, they're not robbing a gun store, right? Where they're gonna need perhaps a firearm for self-protection. The guy behind the counter pulls out his own gun, and then they need to pull out a shootout, right? It's probably not gonna be a shootout in the AT&T store. That's just my guess.
Probably depends on where the AT&T store
Yeah,
is,
maybe.
frankly. But in this case, no, I don't think, but again, we don't know any of that. That is simply inference and conjecture that, in my opinion, goes too far. And allowing to the jury to stack those inferences on each other is a step too far in this case. And the government can't point to anything that definitively shows that advanced knowledge for brandishing in this case.
How do you get around armor? The facts here look pretty similar to our armor opinion.
Well, so in armor, the defendant was clearly the leader. I think that there's some insinuation that Mr. Williams was the leader, but if you look at his conduct, he was the driver. He stole a license plate to conceal the car.
It's not unusual for a leader to be a driver, because then you don't get caught. if those exactly.
Not
if those
here.
in the store get caught, though, it's a smart leader.
But then you also have the red focus that had other people involved. There's not a lot about them in the record, but they were involved the entire time. And I think from a leader point of view, that's even a step further away, that the people in the red focus were not even seen at the AT&T store at the time of the robbery. They all circled it. So it makes more sense that the leader there was in the red focus. Is also, Mr. Williams has only been charged in this one robbery, and there were multiple other robberies. An ongoing investigation is what the jury knew. So the concept that he was the leader, I don't think is strong at all in this case. And that also goes to whether he was the person on the phone, because the government just didn't connect that. It could have been, and likely was, the red focus asking about the way the store was structured, because they weren't there. They couldn't see the back. They didn't know who could come out the back. Mr. Williams was sitting in the back on the side by the store and likely would have known that and not had to ask about it. So we could talk about every bit of evidence that the government posits, but it just doesn't get us toward or forward to that intent and knowledge of the brandishing beforehand. And again, affirmance in this case would substantially change the way this circuit applies 924C sections. Now, your original question was about armor. That was a jury instruction issue. The jury instruction was wrong in that case. But the court said it could not affirm based on the facts beyond a reasonable doubt, and said it's probably enough, but we're not going to do that, and then reversed and remanded for resentencing, and that is what Mr. Williams requests today. I'll reserve the remainder of my time.
Thank you, Ms. Christensen. Mr. Jordan will move to you now for argument on behalf of the appellee.
Good morning. May it please the court. Isaac Jordan for the United States. This case is about a robbery plan that occurred during business hours with an employee present. And just like this court's precedent in Lawson, it's implausible to think that such a robbery plan would not include a firearm designed to threaten or influence the employee that was present. And you spoke about Armour, and those facts are similar to the facts here. The defendant in Armour asked his co-defendant to bring the gun, so he knew it would be there. Mr. Williams had already admitted to knowing the gun would be possessed. And in Armour, the defendant instructed the robbers who were inside the store by radio, and it's reasonable inference that the individual on speakerphone was Mr. Williams. And during that speakerphone conversation, he instructed them on what items to steal, and he asked the victim about a back service road. So the evidence, it's a reasonable inference that Mr. Williams was, in fact, if not the leader, he knew the plan.
The phone call, you have the store employee saying the voice was deep and not a whole lot else. How can we draw a reasonable inference that it was Mr. Williamson on the other end of that call?
So the victim said that the voice was deeper than the two other individuals who were with him in the store. And then one of the investigating officers who testified said that Mr. Williams had a lower voice, but the inference is easier when you put the timeline together. So they get in the back room at 5:49 in some seconds, and that's when the phone call happens. At 5:50 is when the car moves closer to the location that he was asking the victim about. So the car moves to the side of the store, which is closer to the access road behind the store, which is what he was asking the victim about, or the person on speakerphone was asking the victim about during that conversation. So when you put the voices deep and low are similar, and the timing of when he moved and the content of that conversation on speakerphone, I believe it's a reasonable inference that it was Mr. Williams on the speakerphone.
There weren't any phone records, were there, to
No.
corroborate that?
The case, it also matches the facts in Lawson, where the firearm was immediately brandished upon entering the store. The individuals were masked, which all point to a plan, in that plan including the brandishing of a firearm. And also the speakerphone conversation somewhat matches the facts from Lawson, where this court pointed to the fact that the defendant in Lawson was unsurprised by the brandishing of the firearm. And in our brief, we talk about how on that speakerphone conversation, he would have likely heard that the individual was terrified with the gun being pointed at him, and the individual testified to how he thought he wouldn't leave the store alive, and that just goes to the inference that he knew the gun would be brandished because he continued to aid and abet after that fact.
Mr. Jordan, same questions I posed to Ms. Christensen. There isn't evidence here of eyewitness holding up of the gun or pointing to the gun in an intimidation way. I understand you can rely on the jury's potential reasonable inferences here, but where is that line as to the intimidation factor when it comes in? What type of evidence is necessary to reach that intimidation conclusion that leads one to brandishing?
So here we have Mr. Williams drops them off at the store, and he watches them walk into the store with the rifle down his pants. And the officer testified that he saw the rifle, clearly the outline of the rifle, on the individual who was carrying the firearm, and that the individual was holding the firearm in his hand. And that suggests that he was going to brandish the firearm as he entered the store. And
It doesn't necessarily. It could suggest he leaves it in there. I suppose you could argue the outline may be a fact if the employee sees the outline, but I'm trying to discern that line here as to when brandishing gets satisfied. And I understand you can rely on the inferences from the jury, but we've got to set some type of standard, not just for this case, but going forward. Your thoughts?
Well, arguably the gun was already being displayed, which is one prong of the brandishing, and taken together with the plan to rob the store and with the employee being present, with the gun already being brandished, it's a reasonable inference that that brandishing could be then used for intimidation purposes of the employee to get him to do what you want him to do.
Let me continue.
If I may, I'd like to correct a thing from my brief. I mentioned that the jury heard evidence that the investigation was based on a series of armed robberies prior, and that of course was not in the stipulation. And the use of the word armed may have been an inference too far. However, the inference that the investigation was based on prior robberies is supported by the record. There's testimony that the car was being surveilled by the Indianapolis Metropolitan Police Department's covert robbery unit, which of course suggested it was being investigated for robberies. But if there are no further questions,
No, thank you, Mr. Jordan.
thank you.
Ms. Christensen, we'll move back to you now for rebuttal argument.
Thank you, Your Honor. The problem with Lawson and the concept that all robberies must include a firearm to get people to comply simply isn't the way all robberies work. We can't assume that every robbery is going to be a firearm. It may be more successful with a firearm, but there certainly have been successful robberies without firearms. That's a step too far. And the inference, going specifically to the testimony that Mr. Williams was talking while they were in the back. The testimony at trial was that he dropped them off and then drove to the back. And Tucker and Risper spent time in front of the store prior to going in the back of the store inside with Mr. Ray. So the inference that he knew what was going on is simply not supported by the evidence. And then I think the display and intimidation, we do have to draw the line when you're talking about brandishing. And it is display and intimidation for brandishing. That's kind of the boiling it down to the basics. But in this case, the question is whether Mr. Williams knew in advance that the display and intimidation was going to occur. Unless the court has further questions, I'll ask to reverse and remand. Thank you.
Thank you, Ms. Christensen. Thank you, Mr. Jordan. The case will be taken under advisement. That will complete our oral arguments for the morning. Thank you.